Hello, everyone, and welcome to today's AGIL webinar, Race and International Law. My name is Jen Malott from Cambridge University Press. And before we get started, I just want to go over a couple of items so you know how to participate in today's event. You've all joined in listen-only mode. Should you experience any technical difficulties, please add this into the Q&A box, and a member of the organizing team will endeavor to help you. In the unlikely event we experience any major technical issues, we will message the audience and restart the webinar. The link to the corresponding AGIL symposium will be added to the chat in just a moment and can be found at any time at cambridge.org/AJIL. The whole event will take about 1 hour. And to get everything started, I'm delighted to turn things over to Monica Hakimi, who will introduce the panelists.
Great. Thank you, Jen. And thanks to all of you who have joined us today. As Jen said, I'm Monica Hakimi. I'm one of the co-editors-in-chief of the American Journal of International Law, which is sponsoring this webinar, along with Ingrid Brunk at Vanderbilt Law School. And I'm joined today by three really incredible panelists, whom I'm delighted to introduce. So first we have Tony Anghie, who is a professor of law at both the National University of Singapore and the S.J. Quinney School of Law at the University of Utah. He was at the very forefront of a critical movement in international law known as Third World Approaches to International Law, or TWAIL, and a few weeks ago received the Manly O. Hudson Medal from the American Society of International Law, which is the highest honor that the society bestows and a way to recognize his outstanding contributions to the field. In addition, we have Asli Bali, who is a professor of law at Yale Law School. She works in public international law and especially in human rights law and the law of the International Security Order, as well as in comparative constitutional law with a special focus on the Middle East, doing really interesting work on that region. And third, but certainly not least, we have Olufemi Taiwo, who is a professor of philosophy at Georgetown and has recently written an excellent book entitled Reconsidering Reparations, which explores a philosophical argument for reparations and links this argument to issues relating to environmental justice. So thanks to all of you for being here. And just by way of setting the stage for our discussion today, I want to just lay some foundation. So note that by design, of course, international law governs people of all races, and its inspirations and effects are universal, like as in global. But historically, it has not governed people of all races equally. Quite the contrary. It has perpetuated racist practices by providing the legal architecture for, and in so doing, legitimizing and facilitating, perpetrating practices that have systematically subordinated some racial groups, especially in what we now refer to as the Global South. So here one can cite, for example, the use of international law to perpetrate slavery and the slave trade, colonialism, the theft of art or other objects, and the other many other practices that relegate groups of people to the economic, and particularly groups of people of color, to the economic, cultural, and social periphery. And in contemporary international law, many of these frameworks that have perpetrated race-based subordination have, at least as a formal matter, been abolished. And other frameworks, which might have some emancipatory potential, have been adopted. So, but notwithstanding these changes and developments, which of course have been significant, one of the critical insights of TWAIL scholarship has been that the legacy of racism in international law continues in various ways, large and small, to infect the field. And so our discussion today is designed to explore how international law, past and present, deals, or in some cases does not deal, with issues relating to race. I should note that the American Journal of International Law also just published a symposium on race and international law in our online compendium, what's known as AGIL Unbound. That symposium is edited by Tendai Achiume and James Gatti. It's available on our website, and we'll include a link to it in the chat as well as at the end of the webinar so that you have access to it. I recommend it to all of you as well. And so with that very brief introduction, maybe we should start with some history. And Tony, I'll maybe begin with you then. So your work uses the history of racism in international law as a lens through which to understand, I would say, contemporary practices. And I want to ask you why you start with the history and how you use that history, not just to understand the past patterns and practices of racial subordination, but also to identify sort of the patterns of continuity and change over time.
Sure, thanks, Monica. So let me thank Monica and Ingrid for organizing this. Let me thank the AGIL for finally addressing this whole question of race. Let me congratulate James and Tendai for getting this wonderful symposium together, because it has been in the works for a very long time. And it's great to see it out there finally. In trying to address your question, Monica, I wonder whether I might, this question about history and the importance of history, and the question of race and the significance of race in the history of international law. I want to go back to a very interesting and somewhat disconcerting study that James Gathie did in terms of this question of to what extent has the American Journal of International Law featured articles that deal with race, and the percentage of articles is extraordinarily low. And so what I would like to suggest is that a lot depends on how we present international law. So here I'm being just very simple and suggesting that what we need to do, I mean, here, this very discussion is almost reparatory, isn't it? In a certain respect. We're trying to make up for all the past omissions, but there's a long way to go. But the question I have to ask is, why do these omissions arise in the first place? So I think it is because we don't really engage with history in terms of our understanding of international law. And how I try to remedy that, perhaps in a very crude way, is that in my international law class, I teach the course Johnson versus McIntosh. I'm sorry, the case Johnson versus McIntosh. It doesn't feature in any international law textbooks that I know of. It features in property law textbooks, because it's this whole question about, whether Native Americans can actually transfer title. But, to me, it is fundamental to understanding the history of sovereignty in the United States. And if we look at that case, I mean, we study this question of sovereignty in various, we always encounter it in various textbooks, the Montevideo Convention, the origins of sovereignty, how do sovereign states emerge? I think we should study the way in which the United States emerged, and it is Johnson versus McIntosh which gives us a key to that whole process. So we need to study our own history, in that respect. And let me just say then, the type of language that is used and the issues that are raised. So let me just read just a passage from, Johnson versus McIntosh. The accepted principle governing the discovery of barbarous countries by civilized people is that discovery gave the state, I'm sorry, my screen suddenly went blank. I'm sorry. Okay. The accepted principle governing the discovery of barbarous countries by civilized people is that discovery gave the state by whose subjects or by whose authority it was made the exclusive right to settle, possess, and govern the new world, and the absolute title to the soil subject to certain rights of occupancy only in the natives. If we unpack all that, it would take quite a long time. But what we can see is this basic distinction between barbarous countries, civilized people, and this whole question of how that becomes the basis of dispossession, and everything that follows from it. So all I'm suggesting is, if we start with that case, then all the issues of race, and there's a wonderful article by on Zionism. Many congratulations to the authors of that article, John and Noura and Daryl. Race and colonialism are conjoined. That is the argument they make in that article. And if we look at our own history, we understand that it's incomprehensible without looking at this question of colonialism and race. And once we appreciate that, then surely those questions of race extend throughout the course. So in other words, once we make race a central aspect of the race and colonialism a central aspect, and the issues that they raise a central aspect of the teaching of international law, then surely we could say we can't avoid this. We have to address these issues. So that's a very simple thing I just want to say. But I'm also amazed by the history I was able to somewhat inadequately uncover in terms of things like Du Bois and the contributions, his efforts in the United Nations, NAACP, dealing with issues of anti-discrimination and so forth. So I think all those questions can be central to the teaching of international law. I mean, the other way I try to do this is to present Tendai's report right at the beginning of the course. Because once those issues are raised, then they enable us to see all the subsequent material with those issues in mind, rather than the typical classic issues of, how do we create order among sovereign states? Is international law really law? I think a huge amount depends on the questions that we ask from the outset of the course. Once we ask those questions, then we can proceed. So let me stop there just to say, that's the significance to me of history and methodology and teaching, and why, if we don't do that, we're going to find the whole issue ignored. I don't want race to be just sort of added in as a kind of, sort of dessert, or, some kind of secondary, oh, let's just add race in here or something like that. It's integral to the whole discipline. Thanks.
Okay, thank you. That's a wonderful launch pad then for me to sort of ask Asla and Tao each to speak a little bit about history as well, but maybe with a different angle. So Asla, I'll start with you next. Given what Tony says about sort of the foundations of international law and the way in which race is so central in many ways to the enterprise and co-joined with colonialism and these practices that are sort of hidden from view if you start international law from a different frame, from a formal frame. How do you, again, and this is consistent with the methodological question that Tony raised, how do you sort of trace and identify the effects of that history in the current practices that you are sort of exploring today, whether for your students or in your own research and production of knowledge?
Thanks so much, Monica. And while I'm mindful of time, I can't avoid also thanking you and Ingrid, again, repeating Tony's words. It's really so historic and important that AGIL as a whole is addressing these issues. Again, I'm going to sound like I'm echoing Tony, but for the very reason that James's earlier analysis of the total absence of race and racism from the pages of the journal underscored, and which he points to in his introductory, together with co-authored with Tendai, piece on the symposium. And I do think that it's worth underscoring that one more time, the absence of race and racism in international law scholarship generally, as reflected in the pages of the American Journal, because the reason that we need to turn, I'm not trained as a historian, right? That's not the background that I come with, but methodologically it's inescapable that we have to turn and undertake a history of the ways in which these acts of erasure have taken place over time, and then scholarship in the tradition of Thurgold approaches to international law, so Twale scholarship, undertakes a history of race and international law precisely to problematize and resist these strategies of erasure that obscure the role of race in histories of expropriation, dispossession, and even enslavement through the deployment of legal fictions or purportedly universal categories. So to help our students unpack that, to understand how race operates, to make race a central analytic lens in the ways that Tony just suggested and not an add-on to an account of colonialism, we have to actually stop, pause, and focus on what do we mean when we talk about race. And so here, I'm just going to borrow a little bit for a moment, as I do in my actual work, from critical race theorists to say, if we understand race as a historically contingent system of social meanings that attach initially to elements of morphology and ancestry, and that's taking directly from Ian Haney Lopez's work, but also building on the important work of folks like Cheryl Harris and Devin Carbado, then an inquiry in race in international law has to be, of course, we're saying it's a historically contingent system, right? It has to be a historical excavation of the ways in which that system operated to construct race over time. And also then to understand how international law attributes particular social meanings, racialized meanings, to nations, peoples, and individuals that facilitate and entrench global and domestic orderings, historically then, in the ways that you suggested in your introduction, Monica, legitimize conquest, expansionism, slavery, and even genocide, but today continue to legitimize militarism, economic extraction, and other forms of subordination for people that are categorized as, let's say, broadly non-white globally. The history of white supremacist ordering through law is well told and easily told in the domestic context in a country like the United States. We trace the constitutionalization of slavery and then the afterlives of slavery and its entailments following de jure emancipation. So the idea, for example, that the formal abolition of slavery ended race and questions of racism or the central role of race in the United States would be deemed preposterous. And yet at international law, that effacement is a much easier move, formal sovereign equality, and now we're done with this analysis. Whereas in fact, at the international level, an analysis of the role of law in the social construction of race would take that focus on histories of expropriation and enslavement transnationally through colonial and imperial practice, and then look at the aftermath of decolonization also through a racial lens, recalling to begin with, that decolonization entailed, yes, formal sovereign equality, but in exchange for accepting international law rules written by metropolitan states, as well as the continued concentration of material wealth produced by colonization and slavery in the hands of colonizers, with neither redistribution nor reparations following decolonization. So histories of international law that trace the social construction of race that enabled and justified practices of colonization help identify the ways in which the existing rules also reflect the sedimentation of that historical racism and the analogous concepts and forms of argumentation that recur today in the contemporary period, reflecting the very same racial and racist logics. So one example from my own work, and I'll just stop on this because you asked, is, to look at race as historically present in the framing of ideas of humanitarianism that accompanied European conquest, and then by analogy, tying these genealogies to the kinds of logics of humanitarian intervention that today animate military force against, formerly sovereign states of the global South differentially, purportedly to advance a kind of broader set of normative scripts of the international system, but ones that have deep ties directly back to those earlier logics of 19th century humanitarianism, just as an example.
Okay, great, thank you. And then, so Olufemi, I'll ask you a variant of the same question, which is, so you come at this from a philosophical perspective. And so as we talk about sort of different disciplines for or methods for approaching something as complex and ingrained in our social structures as race, how do you use philosophy to understand sort of past and present practices relating to racial subordination in international law? And specifically, how do you use like a conjunction of philosophy and history so as to understand these issues and explore them in your own work?
Yeah, thanks a lot for that question. Thanks, Ajo, for putting this on, and for Azza and Tony for being here. And, my answer to how I use philosophy to kind of frame these issues, or, is maybe better put slightly differently. I think there's a way that I put these issues together, from philosophy as a place that I stand, but I don't actually think philosophy in and of itself is actually up to the task of understanding these sorts of realities in ways that I think are related to what my colleagues have just been saying about law. So like both of them, I'm a philosopher with deep historian envy. I deeply think that I can't even get started doing the political philosophical work or asking those questions without, spending a lot of time with historical works and, talking to historians, because it is just a matter of fact that the kinds of structures of race and colonialism that we're trying to investigate are ones that just are historical. That's what they are at bottom. And understanding that from a philosophical perspective, I think means abandoning some kind of deep philosophical methodologies that are that philosophers are prone to, but I think, in a different way, show up in the legal profession as well. I don't think lawyers and legal scholars are naive. Everyone understands that how law shows up and what it means depends on contingencies of who has wealth and who has power. Those are things everyone understands. But nevertheless, law presents itself as a system of rules, right? It presents itself as proceeding from definitions, as being constrained by case law and interpretations of case law that are plausible. It presents itself as being constrained by precedent. And of course, that's not entirely fictional. There's something to those constraints. But nevertheless, in the broader world of politics and the wild of politics, what you're dealing with is ultimately not a rule-governed system at all. It's not, it's not a system, or to put it this way, if there are rules that govern the political world, they are not the rules that are written down in legal structures. They're not the legal definitions, right? There are treaties saying that the United States federal government had to respect indigenous nations in a certain way, and there were treaties that said that the German government had to pay reparations to France, and one of those things happened and the other did not, and none of us here are confused about why. About why there are those sorts of political differences. And the explanations for those are not in what reparations means or when reparations is really apt from the point of view of a coherent philosophy. But, if we're going to find coherence anywhere, it's in the sorts of distributions of military and geopolitical power that inform who the law protects and who it binds. And so, I think on the methodological understanding realm of things, I think, it's pushed me towards, materialist philosophy that I think is more flexible and more designed to answer these sorts of questions that have often been taken up by critical race theorists as well. And obviously some critical race theorists could be materialist as well. But I think in general, it's pushed me towards that sort of philosophy for reasons I think overlap with the kinds of complexities that are relevant for.
Okay, thank you so much. And so I was going to move on to another question, but I sort of can't resist lobbing this back to Tony, because I feel like you're teeing up so well a question that I think he has addressed at some length, and I'd be interested in hearing more from you about, Tony, which is like this point about the formalism of law and the use of rules and other constructs to erase the ways in which power and other social constructs affect the actual application of law, and oftentimes in ways that subordinate racial minorities or people they're not minority, people from the global South. And so how do you think about law as a sort of an enterprise, which Tao says is like focused around rules and institutions and all sorts of ways of sort of presenting itself as neutral, and the facts that we all know to be the case, which are that race manifests and sort of saturates all of law as it does all socially constructed orders. And so how do you grapple with that tension? You're muted.
Yeah, so one thing I suppose we can try and do is, uncover the history of concepts and the history of legal doctrines, because when we do that, I think we sometimes find or get some sense of the ways in which, explicitly racial doctrines become transformed and appear to be then more neutral. So, it's very interesting, for example, how, so this is why I find history and the history of international law important, because we can see these moments when racial categories get transformed into another language. So the distinction between the civilized and uncivilized becomes, during the League of Nations period, a distinction between the advanced and the backward. And the advanced and the backward brings with it the whole idea of development, and that's an entirely different set of technologies and a more complex language in a way. But if we see how it replaced in some respects, or even continue to work with that original distinction between, civilized and uncivilized, then we can get a sense of how this apparently neutral language is still sort of embedded, originating in this particular way. I mean, I also think that we might use this to advertise the wonderful essays that have been written here in the symposium. And I think those essays do a brilliant job, better than any description I can give. In many cases, especially when dealing with political economy, for example, I think Vasuki Nesar's wonderful essay about about slavery. How literally the slave owners who were compensated then used the compensation that they had acquired to establish factories overseas. So, for example, I think some of the slave owners from the West Indies then established factories in Sri Lanka, which depended on indentured labor or contract labor. And in that context, contract labor was seen as being distinct from slavery. But you can see the whole thick history of the way in which it was this compensation from slavery that then gave rise to this ability to create a different sort of technology of control and power, but one that really continued to operate according to the principles of race. So I think the essays are really great in looking at these connections between political economy and race, and the way in which political economy, Rob Knox's piece on political economy capitalism, sort of creating race as a way of enabling exploitation, which seems appropriate and natural and all the rest of it. And also the way in which categories of race get fused into political economy, which then appear to be liberatory. Okay, contract. How different is that from slavery? But if you see the context, it becomes very a bit more disturbing.
Okay.
And also, let me just say that Matiangi Sirleaf's article about how really health was based on particular ideas. Disease is colored. That had been a long-standing image, and structures of global governance were constructed around that image of disease is colored. And then suddenly we think it's all dealt with, but then suddenly during the pandemic, suddenly those images re-emerge and are very powerfully deployed. So we can see that there's something subterranean about this. And in moments of crisis or whatever we want to call it, suddenly that subterranean racial category, which is the founding principle of the regime in the first place, but which has sort of disappeared, hasn't disappeared, is still there. And then it emerges in this moment of sort of crisis.
Okay, great, thank you. So Asa, I'll come back to you and just ask, given all of this and what we've been discussing, do you think that the tools of international law and the concepts of international law, which have all of this baggage, are actually can actually be used to institute the kind of structural change that many seem to think is warranted, rightly so in my view, or do you think these changes have to come in the first instance from outside the discipline and then sort of be brought into it?
Yeah, thanks so much for that question, Monica. I want to pick up where Tony left off, also celebrating the pieces that we have in this symposium, which are really remarkable, and think about the sort of epistemological construction of international law in a way, like what kind of theory of knowledge is evident in law and legal scholarship. And here, Vasuki Nesia, but also Chris Gevers' pieces are really useful because Gevers highlights how that move of refiguring indentured labor as somehow free in a way because of the deployment of slavery and anti-slavery as now the canonical sort of commitment of international law is tied to the fact that the knowledge of international law, the epistemological stance from which international law encounters slavery is the white abolitionist gaze. And it's a story that white abolitionists, or that white people generally speaking, are telling about themselves. So slavery continues that tradition. Now it becomes just posed as this anti-canon in which, once again, they're the heroes and the progenitors of freedom and universal categories, and are also therefore the appropriate adjudicator of what constitutes free forms of labor by contrast to their deep commitments to anti-slavery. That kind of move, of course, foregrounds the reasons why we might be suspicious that international law is going to furnish us with a set of tools for emancipatory projects. But I think that's not actually the way that critical engagement with international law operates. And I think we see that again in many of the pieces in the symposium. And for example, Matiangi, in that excellent piece on race and global health, ends by looking at possibilities for refiguring the relationship of race and global health in a new platform that's emerging around pandemic preparedness, negotiations, and ways in which countries of the global south, having experienced this sort of deeply disturbing, immiserating, and racialized framing of the pandemic, that we've just gone through are trying to use that as a way of informing an alternative set of practices in a diplomatic forum. But I want to point to work, and here again, Tony has sort of led the way in our discussion, as he has also done in his scholarship more generally, by pointing to the work that Tendai did in her mandate as Special Rapporteur on Racism and Xenophobic Discrimination. She did, remarkable work through her mandate in all of the thematic reports. And one of them that immediately comes to my mind in thinking about this question is her report on global extractivism and race, where she tries to work her way through what would it mean to use the international framework that we have available through human rights law, right? Which is very different. It's not, anti-discrimination law in the domestic context exemplifies the kind of so-called neutral and so-called colorblind approach to purposive and intentional discrimination in forms of bias that, again, the white abolitionist gaze spurns and enables us to reject, while perpetrating and turning our attention away from structural forms of discrimination, racism, and in fact, all of the other things that actually have come back in as a consequence of, once again, decolonization and the presence at the table in the negotiations over the Convention on the Elimination of Racial Discrimination. We get a very different articulation of what the anti-discrimination norm means globally. And then we have a set of invested political actors, even entrepreneurial actors, that inhabit the roles of mandate holders, exemplified, for example, by the work that Tendai herself did in this role, in order to advance an idea of global racial equity. What would that mean? What would anti-racism, systemic anti-racism look like at the global level? And then when you examine closely what the work actually entails by looking at a report like the one that I just named on global extractivism and racial equality, we see a mix of methodological approaches that are both deeply critical, very much historically informed. If you look at the structure of the report itself, it's like it offers you a history, then it offers you a political economy, then it shifts back and reminds you of the doctrinal differences between the, sort of the neutered and so-called neutral anti-discrimination frames that are conventional in domestic contexts like that of the United States, and the much more robust potential that's available in the normative framework that the CERD committee has commended to our attention, that attends both to structural discrimination impact, and suggest ways that we could use that framework of understanding global racial equality, to contest and challenge the operation of the political economy of extractivism. So that gives us an idea. Now, does she suggest, or would we suggest from a TWEL perspective, that international law has the tools within it to take down the master's house? No, that's not going to be a move that anyone's going to endorse, because there's no question, given what I said a moment ago, decolonization without reparation means that material wealth accumulated through enslavement and expropriation remains overwhelmingly in the hands of the global white, if you allow me to say that, or the global north. And so long as that remains true, we're not going to be able to have meaningful emancipation that is thoroughgoing and structural through international law alone. Although we can do things with the existing norms as we reinterpret them, we do the kinds of projects that also the wonderful article by Sarah Riley Casey suggests in the Caribbean community context around the Reparations Commission, of connecting histories of racial exploitation to histories of ecological injustice and demanding reparations. And of course, Femi's work also points to a climate justice idiom in international law that foregrounds race. That also is a possibility that is being forged through international law tools. But of course, with all of these kinds of 2 steps forward, 1 step back possibilities that may exist at the margins by using the tools of international law, at the end of the day, we need political mobilization for mass redistribution. That's the truth of it. And that's why reparations is an important frame in thinking, and it's a frame that international law can help advance, or of course can retard. And what we see, and I'm going to just stop with this, in the, again, essay that Tendai has done with Gay McDougall in this symposium once more, is the sort of forces that are waged against the possibility of any kind of an emancipatory project through international law. You have a global racial justice uprising in 2020. You have the mobilization of the entire African Union to insist that this become a focal point for the UN Human Rights Council. And you immediately have the Western European and other states group mobilized to block that, to prevent it, to put obstacles in front of that project. And then over time and through contestation, you still get certain victories, more limited than the demands that 2020 made possible as a consequence of global political mobilizations. So we can see that 2 steps forward, 1 step backward history being told in real time, in current history right now, and narrated in this symposium, importantly, that reminds us of the inside and outside, both and function that we need to focus on if we're going to try to do work around global racial equality that is both using international law and contesting international law as an emancipatory frame.
That's super helpful. And Olufemi, I just want to hand this over to you. ASLA says a lot about reparations, about trying to institute at the global level a project of racial equality, of instituting an anti-racism agenda. And so this just ties in so perfectly to your work, climate change as a particularly racialized issue, in fact. And so this just ties so well into your own work. And so I want to ask you to speak about reparations in particular in the climate context and more generally, and how you see both the prospects for real reparations and the kind of redistributive justice that ASLA mentions, as well as some of the impediments to it.
Yeah, I think, the question of redistribution on a global scale, and in a way that's informed by history, is what I take reparations to mean. And so, or at least for the purposes of how I've used the term, it's not obviously new to me. The Caribbean Reparations Commission, the discussion from the People's Agreement of Cochabamba about ecological debt, or, earlier discussions about ecological debt in the 90s, have been making this point about the kind of united nature of the broader ecological crisis we find ourselves in, of which climate crisis is an important component, and the history of colonialism and economic development and monocrop agriculture and all of the things tied together with what has built the present historical order. And finding a way to redistribute wealth, decision-making power, and redistribute carbon and water, all these kind of literal historical tasks that are going to be in front of us over the next few decades, the remainder of the century, is, I think going to take a Herculean effort. And if we want it to succeed, I think it's worth thinking about the kinds of Herculean efforts in the past that have led to broad planetary scale changes. And the one that I always find myself mentioning in cases like this, in conversations like this, is the planetary political transformation that happened over the 20th century, but especially the back half of the 20th century. And the headline, the thing that often gets commented on when this period is discussed at all, all of our disciplines are very ahistorical, but of course people talk about the Cold War and the sort of proxy struggles between the United States and the Soviet Union. And that period of history certainly involved that kind of struggle, and that's pivotal to understanding what happened in the back half of the 20th century. But the other thing that happened was mass decolonization, or at least a massive setback on the political dimension for the formal version of colonialism. The number of member states of the United Nations more than tripled over the decades from the height of the British Empire in the 1910s to the 1980s. And what that took had an ideological dimension, right? People were contesting what colonialism was and whether or not it was good. People were contesting the basis for the present distributions of wealth and power, like apartheid, throughout the African continent, and Jim Crow in the United States, and racial segregation many other places. But here, the Cold War and the geopolitics creeps back in. I think it is part and parcel of the story of why movements for justice were successful, where they were successful, that, among the strategic complications for the powers that wanted to maintain the racial hierarchies as they were, was this battle for hearts and minds that had to do with literal battles, wars of independence raging throughout Asia and Africa, in Vietnam, in Angola and Mozambique, the struggles for independence that are happening in the Indian subcontinent, so on and so forth. And I think without stakes of that kind for the ruling class, it's very difficult for whatever ideological purchase we're able to make, amongst us, the literati. It's hard to get political teeth on those without those kinds of stakes to the struggle. So this is mainly just echoing the point that Aza put really well just now. But I guess the dimension that I would add is some kind of geopolitical contestation over power at a planetary scale, I think, is going to be necessary to shake loose political opportunities at lower scales, at national scales, at subnational scales. And the kinds of South-South cooperation that we're seeing, perhaps between China and Brazil, some of the AU unity on particular political issues, as Aslı just mentioned, I think is the kind of pressure that could make more serious, more sweeping change possible. Because, as I've been saying, over the 20th century, it's the kind of pressure that we did in fact see make that kind of change in fact happen. And so that level of politics, again, is something I think worth thinking about directly.
I couldn't agree more. And I want to follow up on one question with you, please, Olufemi, before I then ask Tony a follow-up question, which is, so we're in a moment, I think, of significant geopolitical change. I think a lot of people would say that, not just me. And one question I have is, how do you think about the way to use this moment of geopolitical restructuring in the service of these projects for emancipation, as opposed to in the service of the projects for further subordination and subjugation? And in particular, like, who are the agents who ought to be given the tools to advance the former and make sure we retard the latter? And are those agents necessarily state agents? Are they necessarily state agents in the global South? Like, how do you think about actually programmatically moving in the direction of positive as opposed to negative change at this particular moment?
So the organization that, or the kinds of organizations that could, I think, play a primary front and center role in that kind of change would have to hit a pretty difficult sweet spot. On the one hand, they would have to be powerful and influential enough that they could actually move politics at scale, including the political dimensions for ruling class institutions like the more powerful states. But they couldn't be so powerful that they just already function almost entirely as engines for the political wishes and whims of the wealthy and hyper powerful already. And, if you've all right, I'm going to give a very unsurprising answer, I suppose, but unions. And historically, the kind of gold standard has been the International Trade Union. There's good reason for that. But, I could imagine larger tenants unions making that kind of a splash, groupings like the landless workers movement in Brazil, making that kind of a political difference at scale. But I think those are, engines of democratic process and democratic progress as well, that have the ability to speak to the ruling class on, the terms of violence, which are the only terms that they understand. If you don't stop destroying the planet, you don't get your precious little dollars, because we can, withdraw our work and withdraw our labors, or withdraw our rent, or withdraw our payments for energy bills, whatever the area of leverage is. And again, hearkening to history, that's a way of organizing politics, or at least a component of a broader social movement politics that we've seen be effective in the past. One of the things that I think is fair to say was pivotal in toppling the apartheid regimes in Southern Africa were, workers organizing transnationally. That includes, of course, the trade unions in South Africa and, their allies in the ANC and the SACP. But it also includes the unions outside of South Africa, outside of Southern Africa, who in solidarity were demanding boycotts and divestments and sanctions for the South African apartheid regime. And I think, there's been a deliberate attempt to airbrush that story and many others and make it sound as though Nelson Mandela was just brave and everyone just realized he was brave one day. And that's why there's no apartheid anymore. But, I think we all know that the story is more involved than that. And one of those extra dimensions that people don't talk about is the direct kind of pressure that organized non-state actors that are organized around movements that are solidarity based can have on politics, and not just politics at a local scale, but politics at a planetary scale.
Great, thank you. And so, Tony, I sort of warned you that I was coming to you next, and so here I am. So Tao, just to piece together a couple things that Tao just mentioned. First of all, the need for dramatic, transformative, planetary size change. Second of all, the focus on non-state actors as agents of change. And third of all, the decolonization movement being a sort of precursor of this kind of moment in international law, where the basic structure of the system was being transformed fundamentally. And I guess the question I want to ask you is, having talked about now a little bit the role of non-state actors as sort of agents for change, how do you think about the role of states from the global South as agents for change? Given something that sort of Tao hinted at, which is that many of the leaders of these countries have no interest really in fundamentally transforming the structures in which they now operate, because they are benefiting from those structures themselves. And yet those structures are designed to sort of prop them up as agents of the state, at least the structures of international law are. And so how do you think about the proper role of, or the desirable role of, states from the global South in trying to institute the kinds of changes that we're talking about today?
Okay, lots of tough questions here. Let me just say a bit about reparations, if I might. So, of course, Asla and Olufemi are quite right. That is what is needed. But my own view is that we have what I would call a set of reverse reparations, which is that the South keeps paying reparations to the North. And for me, the Haiti episode exemplifies this perfectly. And if we have a look at the condition of many of the southern states, what we find is that we can see this, that the acquisition of sovereignty is completely, very often also accompanied by the acquisition of debt, because colonial debts passed on to the new states. And if we have a look, for example, at the debt regimes that are in place globally now as a result of the IMF and the World Bank and the various other financial practices, policies, and institutions, we find a massive transfer of wealth from the South to the North. So I think there's a system of, there are two systems. There's the reparations claims of the South, which are facing all sorts of legal obstacles. and which are seen as being massively politically undesirable because they are so disruptive to the way things are. But I would say that there is a well-established northern system of reparations or western system of reparations. Have a look at investor-state dispute settlement. Here we have corporations winning awards of like $4 billion, $6 billion. Those would wipe out the health budgets, the education budgets of many smaller countries. And that system is well and truly in place. It's not something that is, in the course of being constructed. I can't help finding it very fascinating that in international law, the classic case for the proposition of reparations is called the Chaucer factory case. Now, the interesting thing is that in terms of reparations, even when we talk about human rights reparations, we cite that case. It is cited by Tendai in her report, for the proposition of reparations. But then think of who is being reparated here, if that's the right word. Is there such a word, reparated? It is a corporation. So this is what I mean by saying, let's trace the history. It is the reparations of a corporation that have structured, you could say, the modern law of reparations, which continues to have a massive impact through investor-state dispute settlement, but also I would say, through the debt regimes and so forth. That is the paradigm that is already in place, and the southern reparations are trying to catch up in this sort of situation. Now, quickly to the question of southern states, I think to add to what Olufemi mentioned, I do think it's important to understand the new international economic order and the amount of solidarity that it created and the ambition of that scheme, and just how powerful it was in so many respects. So I'm not sure whether that moment will come again. But to me, that continues to be something that we can think about. I do agree about this whole issue of southern elites taking over the state. And of course, it's this tragedy where all the technologies of control and power of the colonial state are now being precisely used by the post-colonial elites. Prevention of Terrorism Acts, for example. All those disciplines are now being used by those elites. I mean, just to add to what Aslan Olufemi mentioned, I mean, I see, I think what's happening now is a system of sort of global marginalization and dislocation, Saskia Sassen, the whole question of, dispossession exclusion. And I don't know what politically this will bring about, but I think there's this huge groundswell, and how that would be organized to bring about change is, something we still don't know much about.
Asla, I see you gesturing. I was actually just going to try to squeeze in one more question to you before we run out of time, but is there something that you want to say?
Well, I also know that Femi had a point. So just in the service of sort of conversation, I had a reaction to something Femi had said. Femi is having a reaction to something Tony said. So I'm not sure how you want to manage the remaining time. I'll leave that to you, but we're all chomping at the bit in our own way.
Go ahead.
You want me to go? But okay. So I'll just say, just a, enormous doubling down on Femi's points about, unions, civil society, like the non-state actors, that this is the place. And actually the point he made at the very end that made me want to intervene was that this is how apartheid ended. And of course, we're in a moment, and the symposium draws our attention to ongoing apartheid practices as, multiple Israeli, transnational, international organizations, human rights organizations have found in the context of Israel. And again, we find here a civil society mobilization around BDS. And we can see, on the one hand, one listening to this conversation might say, okay, Femi described a sweet spot. Is it really possible to imagine that unions globally today have enough power to really enact a transformative vision in that sweet spot? Do they? I mean, it's clear that they don't have the power to benefit from and construct systems of subordination. They're not currently today responsible for those systems, and they don't extract value from the systems, but do they have enough power to disrupt them? Are they in that sweet spot? And in some ways, looking at the fate of what's happening with BDS and the call to BDS right now is instructive, because even as many actors in the global north and conventional international lawyers would poo-poo the idea that civil society actors or non-state actors are in a position to mobilize movements that could have a meaningful planetary transformative effect, they're also busy drafting up the rules and making sure that law clamps down on any possibility of this kind of mobilization, precisely because the mobilization has real global potential. And we're seeing it even in the most unlikely places, which is to say in the metropolitan capitals that have enabled those structures to be put into place. And so it's a really instructive place to look. And therefore, I want to just echo again Tony's celebration of Daryl, John, and Noura's contribution in that piece. And then step back to the core point you were trying to make, I think, Monica, which is directing our attention to both critiques of the state in the global south, and TWAIL is full of critiques of the third world state. Clearly, it's operating in a kind of neo-colonial indirect rule system as the intermediaries, the state elites as the intermediaries of essentially the very projects that we've been describing. But at the same time, you're also pointing to geopolitical fragmentation and the fact of inter-imperial rivalry. And does that produce opportunities for leverage that could possibly generate an emancipatory moment? And, I think that does bring back the NIEO. It brings back the question of, is there a possibility of some kind of a solidaristic politics that takes advantage of the space produced by imperial rivalry to generate a non-aligned or a different position that is a place of building our own power, if you want, a place where reforms in the international sphere could be imagined. I mean, all of these kinds of moves. I think that's on the table. I mean, of course, none of us have a crystal ball. We're not going to be in the business of prediction. That possibility is there, but it's there, of course, as it was in the Cold War, with a troubling dark side, which says the other face of the mirror, which says, planetary extinction is also on the table. Nuclear annihilation is also on the table. Ecological catastrophe on an unimaginable scale is on the table. And so just as the very possibilities that the NIEO tantalizingly placed on the agenda were then superseded by, a catastrophic consolidation of neoliberal political orders. So today we're on the cusp, I think, of a moment where many possibilities are available. Alternative futures can be imagined, alternative histories can be retrieved, but it's a dangerous moment. And I'll stop there. And I know Femi wanted to come in too.
Thank you. Femi, please go ahead. I am cognizant of the time, but I do want to also give you just one last minute.
Yeah, I'll be very quick. I totally agree with what Ala just said, but I did want to address, prescriptively, what would it be good for international law and international lawyers to be involved with? And I think, oftentimes we kind of overthink it, and where we address all these deep conceptual problems that there are in the way the law is framed and the way people think about the law, and how the law gets built. Honestly, it would be a major advance over the status quo if some of these multinationals just actually had to follow laws, right? If there were a huge litigation offensive against Glencore, against BHP Billiton, against these, these supervillains that are just doing the most egregious, we're not talking about, small accounting errors. We're talking about murders, bilking, bribery. If there was an organized offensive against those people, would it even the playing field between mega corporations and unions? No, but would it, put us in a better position than we're in now? Yes. So, I just wouldn't overthink it. Just go on offense.
Great, thank you. And I think everyone can just feel the urgency that we all have in our voices about the current moment. So thank you, Asa, Femi, Tony. This has been an extraordinary discussion. Of course, there's so much more to say. And so hopefully we'll continue these conversations in various spaces, both within AGIL and outside of AGIL. I want to recommend to everyone, again, the Unbound Symposium, which we've all sort of mentioned over the course of the webinar. It's extraordinary. And I want to thank CUP again for hosting us, and most especially thank the three of you for being here. I've learned a lot. I'm sure that our listeners at home have also learned quite a bit.
Thank you so much, everyone, for joining us today. We'll be we will be sharing a recording of this conversation within the next week. It will go out to all the attendees. And the AGIL Unbound Symposium on Race can be found at the journal's website at cambridge.org/AJIL. And thank you again to everyone who's here, and thank you so much to our panelists and our hosts.
Bye, everyone. Thank you.